Think about the sweeping policy changes that happen when a new administration takes office. While the formal legislative process outlines how laws are created by Congress, it is the federal bureaucracy that turns those broad laws into daily realities. The federal bureaucracy is made up of millions of civil servants working across hundreds of departments and agencies. Because Congress often writes legislation in broad terms, these agencies possess a powerful tool known as bureaucratic discretion, the legal flexibility to use their technical expertise to determine exactly how laws will be enforced. Today, we are breaking down how agencies use this discretion through a structured cycle called rulemaking, and how a landmark rule ensures this process remains fair, transparent, and bound by the rule of law. Members of Congress are generalists. They cannot possibly be experts on every technical issue, from environmental science to aviation safety. Therefore, federal legislation frequently sets broad goals and delegates the specific details to specialized agencies. When an agency defines these details, it issues what the law calls a rule, a formal statement designed to implement, interpret, or prescribe policy. Once finalized, these administrative rules carry the force of federal law. However, agencies cannot simply change rules on a whim. To prevent arbitrary decision-making, Congress passed the Administrative Procedure Act, or APA, in 1946. The APA establishes a strict, mandatory sequence that agencies must follow before a rule can take effect. First, the agency must publish a notice of proposed rulemaking in the Federal Register, the government's daily journal, notifying the public of the intended change. Then, the agency must open a public comment period, typically lasting 30 to 90 days, allowing citizens, industry experts, and organizations to submit data and feedback. Lastly, the agency must review the comments, adjust the proposal based on the collective evidence, and publish the final rule with a clear explanation of its reasoning. The entire process routinely takes anywhere from 6 months to several years. A common misconception is that because the president heads the executive branch, they can use executive orders to instantly rewrite these bureaucratic rules. However, as detailed in our policy brief about limits on presidential executive orders on everythingpolicy.org, presidential power faces strict statutory limits when interacting with the bureaucracy. While a president can issue executive orders to set national priorities or reorganize agencies, they cannot use them to bypass enacted laws or rewrite existing administrative rules overnight. If a presidential directive requires an agency to change how a federal statute is interpreted, that agency must still comply with the APA's lengthy notice and comment process. We saw a demonstration of this constitutional dynamic in early 2025. Between January 20th and April 21st of 2025, President Trump issued a historical high 129 executive orders designed to implement major policy shifts, ranging from changing federal worker guidelines to canceling certain federal science grants. Because many of these orders attempted to rapidly alter existing agency rules without going through standard administrative channels, they faced immediate legal challenges. By late 2025, at least 202 lawsuits were filed in federal courts challenging these executive orders. 60% of those lawsuits explicitly argued that the administration failed to follow the required procedures of the Administrative Procedure Act. In multiple instances, federal judges stepped in and issued injunctions, temporarily halting the implementation of orders, such as those involving transgender passport identification and federal personnel changes, while courts assessed whether the administration bypassed the mandatory rulemaking steps. A specific example of this is Trump v. Slaughter, which is a United States Supreme Court decision regarding the constitutionality of statutory removal protections for the Federal Trade Commission and whether a federal court may prevent removal from public office. Another example is the Chevron Doctrine. Under the Chevron Doctrine, federal courts would be able to defer to an agency's interpretation of an unclear statute. This doctrine was overturned in a recent Supreme Court case, Loper Bright Enterprises v. Raimondo. This means courts will have more power to make decisions, and they will defer less to the government agencies. The relationship between presidential directives, bureaucratic discretion, and the Administrative Procedure Act highlights the enduring strength of our system of checks and balances. It ensures that even the highest office in the land must respect the structured, transparent procedures established by law, ensuring that when a government seeks to change how a law is implemented, the public is given a voice. Understanding how the bureaucracy operates helps us see how policy changes are balanced against legal protections. If you found this breakdown helpful, please leave a like on this video and subscribe to Everything Policy for more facts first, policy information. Thanks for watching.